Hi everyone and welcome to today's webinar. We're discussing who's who in the child protection system. My name is Catherine Bowden. If you don't know me already, I'm the Community Legal Education Officer here at Legal Aid Queensland. I'm not on camera today. Today I've got a wonderful panel with me who I'll introduce after some housekeeping slides. I'd just like to acknowledge and respect the First Nations custodians on the land where our office stands. The panel and I are in Herschel Street in Brisbane CBD today, and just acknowledging where we work and where the other organisations work today to help Queenslanders. We pay our respect to elders, law, customs and creation spirits, and recognise that these lands have always been places of ceremony, teaching, research, learning, and acknowledging the important role that Aboriginal and Torres Strait Islander people do play in our community and in improving our legal system. I'd love to introduce our presenters. From Legal Aid Queensland, we have Georgia. Georgia's a senior lawyer at Legal Aid. From Office of Child and Family Official Solicitor, we've got a senior legal officer, Essie. Director of Child Protection Litigation, I've got Nicholas, a principal lawyer here today. And I've got Mark Sprenger, who's a manager of Community and Visiting Advocacy. And Mark is from the Office of the Public Guardian and will be here to answer some of your questions at the end of our slides. Just letting you know that the webinar is being recorded as normal, and we will be publishing the presentation on YouTube within the following week. So you are welcome to share that with other community workers and professional networks and use that for your in-house training with staff. I'd like you to download the handout if you haven't already. You're welcome to read through these at the same time, and there is a link in there for IT support if you are having any issues with GoToWebinar today. If you've got questions, feel free to jump in and type those in the toolbar as we go. All right, we're going to run a poll to start off today. And we're just wondering where you work: Southeast Queensland, Far North Queensland, Regional Queensland, or outside of Queensland. While you're answering the poll, I'd just like to say a big thank you to our Auslan interpreters and our live captioner that are able to provide such a valuable, accessible service to us today. All right, I'm seeing the results coming in, and many of you are from Southeast Queensland. We've also got a lot of people from Far North Queensland and Regional Queensland, and quite a few of you from outside of Queensland. Just a reminder that our offices are based in Queensland and is aimed at people within Queensland today, but feel free to listen in, and if you do have any questions, you're welcome to ask those as well. All right, and one last poll before we move into our content. We're just interested to know what everyone's role is. You might be a family worker or community or support worker, health or education worker, social worker, a lawyer or community lawyer or other. And just a reminder that our panel discussion today is aimed at people who don't have a prior background of law. And the point of today's session is just to be able to allow everyone to have access to further information that could help your clients. We've got a lot of lawyers today, mostly lawyers actually, and we've got some family, community and support workers, social workers, and other as well. So thank you very much for forming our audience today and participating in the polls. I'd love to hand over to Georgia from Legal Aid Queensland. Georgia's going to be running through what we'll be covering today.
Everybody, thank you so much for attending today. We're very excited to talk to you about the various different people who can be involved in the child protection system. The topics that we'll be covering today are: who are the people at child safety that your clients are likely to engage with? the different stages of a child protection order application and the litigation process, and who are some of the key people involved in those legal processes. So it's really an overview of most of the people that your clients are likely to come into contact with in the event that they find themselves in the child protection system.
All right, we're going to run through Department of Child Safety, Seniors and Disability Services.
Good afternoon, everybody. Thank you, Catherine, for introducing me at the start. My name is Ese. I am part of the Office of the Child and Family Official Solicitor Unit that sits in child safety. So I am predominantly here to talk about child safety. You often hear us referred to as child safety, the department, or DOCS. But in general, we are the lead agency when it comes to child protection and adoption services here in Queensland. In terms of our vision, you can see there we are Child Safety, Seniors and Disability Services, but our vision is really focused on ensuring that Queensland children, young people's families are safe and empowered in their culture and communities to thrive socially and economically. In terms of our aim, we really want to keep children and young people and their families safe and connected in their culture and communities. If I can now turn to speak, Catherine, specifically about the roles in child safety. So probably a really important role that it's important for the public to be aware of is the child safety officer, because they are the person that has the most contact with our various families. So when we have a child or children that are involved with our department, they will be allocated a child safety officer. And what this person does is they predominantly conduct the assessments around whether a child is in need of protection. They are the one that also assesses what the appropriate intervention is. And usually you will see their names appear on affidavit material. Now, they don't have as much delegation to make decisions. For example, if someone you're working with needs some changes in family contact or placement or change in the type of intervention involved, the person that they need to seek approval from is the senior team leader. And in normal cases, it's not unusual for certain families or children to go through different child safety officers, team leaders, as well as office, depending on what type of intervention is in place at that time. So continuing to talk about child safety officers, you'll see that in our service centres, most service centres, and I say most because not all look the same across our regions, have an investigation and assessment team. And what that team does is whatever information comes through, that team looks into that information. Not all information is investigated if it doesn't meet the necessary threshold, but information that does lead to a formal investigation assessment, this team of child safety officers who are looked after by a team leader will look into the situation and work out if the child is in need of protection or not. Now, following that process, what then happens is, which you will often see, change of child safety officer, depending on what intervention is assessed for that family. It then moves on to another team that would have another child safety officer allocated with a senior team leader who will then support the family depending on what type of intervention that is. Now, moving on to talk a little bit about the senior team leader, they are the ones that are responsible for supervising a team of child safety officers. And they'll be involved in case consultations, family group meetings, court audit conferences, and interviews with experts. And if I could just make it very clear, which I mentioned before, the senior team leader is the person that usually has the delegated authority to make decisions around family contact, for example. So it's not unusual, should you be supporting a family and you're wanting a change in contact, that your child safety officer may say to you, I will take back the information you've given me, I need to go and talk to my senior team leader about that. Now, the department is very passionate about working with our First Nations people. And this role is a role that I would say has been erected for that, as one of the steps that we've taken as a department to try and work better with our First Nations people. So there are usually cultural practice advisors that also sit in the child safety service centres. Now, their job is to work with our Aboriginal Torres Strait Islander families. They provide the quality, culturally safe and the appropriate advice to our service centres as well. So they have that cultural lens to be able to inform us and advise us on how we can engage our First Nations families better. And they ensure that children and families of Aboriginal Torres Strait Islander are provided and supported with culturally specific services and care. Now, moving on to talk about child safety support officers, that's a different role again within our service centres. Now, their job is not to assess, and that's very important because sometimes our families do have a lot of interaction with our support officers, but they don't have any powers to make any decisions, especially around contact placement. I've named a few already. Their role is to support. So you may see them undertake tasks such as supervising contact and transporting children. Now, the family group meeting convener, another role in the service centre, or sometimes depending on which region, sometimes they sit regionally, their job is to organise the family group meeting process. So they will often do the liaising between the service centre and the parents and the families, including children, if appropriate, and they will prepare and organise the family group meeting, making sure that that meeting does discuss all the harm and the worry statements that for that particular family, whatever that intervention looks like, and they facilitate that process and make sure at the end that there is a case plan that is put in place for that family. Now, the other child safety staff that you will see in a service centre is a senior practitioner. Now, their role is to support child safety staff in making the best decisions for children. They get involved in practice panels. That's a meeting that happens within the service centres. Sometimes there may be critical friends that are invited to partake in that panel, and their job is to really bring that practice experience and that practice knowledge to that panel discussion. Now, generally, legal practitioners acting for respondents and other parties do not have contact with the senior practitioner. And then you have the manager, and the manager holds all the delegation with respect to approving expenses, such as expert assessments and also managing complaints. Now, I just want to talk a little bit about my particular office. So this is the Office of Child and Family Official Solicitor, which was created 1st of July 2016 in response to the Carmody inquiry. Now, this unit is predominantly, or if you were to put it in lay terms, something that's easy to understand, is it's the in-house legal team for the department. They're lawyers that work within the child safety service centres, and you'll see them spread across Queensland. Now, the OCFOS team, they usually represent, sorry, Catherine, we are on the next slide, child safety and when we're seeking emergent orders. So you'll see them involved in temporary assessment order applications, applications for court assessment orders, as well as temporary custody orders. Now, they represent child safety from the time that we commence an investigation assessment. Once that's finalised and an intervention, has been determined that's appropriate for the family, once it becomes a potential child protection order, that is when we brief that out to our Director of Child Protection Litigation Office, which we have here today as well, and they can expand further on the work that they do. Just for general knowledge as well, for those who might be interested, we also are involved with family law court matters, so we represent the department for those matters as well as adoptions. And just in general, we do work collaboratively, with our DCPL colleagues who are here today, ensuring that we do the best and the right thing by the families that we serve. So that's all from me. Thank you.
Thank you. Georgia, was there a question you were hoping to ask Essie today?
I think the question that I had in mind, Essie's actually already covered because she's very thorough. It was really about the way that sometimes clients can interact with multiple CSOs and team leaders throughout a process, but Essie very clearly elaborated that that's depends on where they are in the process, and as they progress, they'll meet with different teams. So that's something that our attendees might have experienced their clients reporting to them, that they've spoken to quite a few people. I think you've done an amazing job of elaborating why that is, because in the early days of my practice, I found that confusing. So thank you for explaining.
Thank you. All right, moving on, Director of Child Protection Litigation.
Good afternoon, everyone. My name is Nicholas Domerow. I'm a principal lawyer with the Office of the Director of Child Protection Litigation. So the Office of the Director of Child Protection Litigation, or the DCPL, was created on the 1st of July 2016 following the recommendations of the Queensland Child Protection Commission of Inquiry. It is an independent statutory body. It is a unique model in Queensland relative to other states, and our office sits within the Department of Justice and Attorney General. So we do sit separately to Child Safety, who are, of course, under the Department of Child Safety, Seniors and Disability Services. Whilst we are separate departments, the Office of the Child and Family Official Solicitor, Child Safety and the DCPL do work closely together. And in fact, within the legislation, it's required that Child Safety and DCPL do work collaboratively with each other. The DCPL's main principle is that the safety, well-being and best interests of a child, both throughout their childhood and for the rest of their life, is paramount, and that's consistent with the Child Protection Act. The Office of the Director of Child Protection Litigation is led by the Director of Child Protection Litigation, who delegates functions to staff within the office, and this is predominantly to applicant and file lawyers, who I'll speak a little bit more about shortly. The DCPL has various functions as set out under the Director of Child Protection Litigation Act 2016, and that's primarily in relation to preparing and applying for child protection orders, transfers of proceedings, and preparation and the conduct of appeals of decisions of the Children's Court. There is some work in relation to other areas, including legal proceedings under the Adoptions Act. The Director of Child Protection Litigation operates as a centralised model with staff based in Brisbane, and staff do travel to various locations throughout the state as required. In terms of an overview of the process when the DCPL does become involved, that's when Child Safety assess that a child is in need of protection and that a child protection order is required. So at that point in time, a referral is made to the Director of Child Protection Litigation. I would stress that the DCPL is not able to take any action in relation to a child unless and until a child has been referred to the Director of Child Protection Litigation. So just to touch a little bit more upon the referral process, a referral consists upon a brief of evidence, and that contains an assessment from Child Safety around the type of order and supporting documents. When a referral is made, a child might be subject to any range of existing intervention, and that might be, as Essie has outlined, a range of orders such as temporary assessment orders, court assessment orders, or temporary custody orders. Sorry, thanks, Essie. The child might also be subject to an existing child protection order, or potentially no intervention at that point in time. When dealing with the referral, the DCPL makes an independent decision around whether to apply for a child protection order, and if that step is taken, then proceedings have been commenced before the Children's Court, or alternatively to refer a matter back to Child Safety, and that would result in there being no ongoing proceedings before the court. In Queensland, the only person that can apply for a child protection order is the Director of Child Protection Litigation. In terms of, as set out here on the slide, once the DCPL have commenced proceedings, the DCPL is responsible for the conduct and management of the litigation. So what that means is that Child Safety continue to be involved with the family and importantly undertake casework with the family. But the DCPL has the ultimate decision making around what sort of application is before the court and is not bound by what child safety's assessment is, but certainly is very much guided by child safety's work with the families. When making an application to the Children's Court, I'm mindful that not everyone here is a lawyer, so I'll just step out very quickly the types of orders that the DCPL can apply for. So that can include in-home orders, such as orders that require child safety to supervise a child's protection, or orders that direct a parent in relation to a parent's contact with the child, or otherwise directing them to undertake certain things or refrain from doing things related to a child's protection. The other category of orders relate to out-of-home orders where a child is in out-of-home care, and those can either be short-term custody or guardianship orders, or there are several types of long-term guardianship orders under the Act as well. When dealing with a child protection referral, the DCPL may take a different view to child safety in terms of what child safety assess as an appropriate type of intervention. And that may be, for example, taking a different view on whether a long-term or a short-term order is appropriate, and that's ultimately based on an assessment of the strength of the evidence. So if I can move on to the next slide, a parent or external stakeholder would predominantly deal with either an applicant or a file lawyer within the DCPL. And each matter that's active with the DCPL has an applicant lawyer and a file lawyer attached to the matter. So there are 2 points of contact for each matter. In terms of the role of the applicant lawyer is either a senior lawyer or a principal lawyer within the DCPL. And at the time that a referral has been received, it's the applicant lawyer that will consider the matter and make a decision around whether to file an application for a child protection order, and decide what type of order that would be. The applicant lawyer does have the delegation to make decisions about the type of order that's being sought, and at any point throughout the proceedings to amend that application. In terms of, or in a practical sense, the contact information for the applicant lawyer does appear at the bottom of the child protection order application. So that will assist parents or anyone else involved to identify who is involved with the proceedings. As noted at the bottom here, applicant lawyers typically appear at final hearings, interim hearings, and quarterly conferences. I'll speak a little bit more to that shortly. But moving on to the next slide, relating to the role of the file lawyer. The file lawyer has day-to-day management of a matter while it's before the Children's Court and works together with the applicant lawyer. A file lawyer is typically assigned a particular court location. So for larger courts such as Brisbane, Beenleigh, or the Ipswich Children's Court, there will be multiple file lawyers because of the number of matters before those courts. For other centres, there will be one file lawyer, and that's examples of that might be Rockhampton or Mackay. And then, as well noting, there's quite a number of people here today from regional or far north Queensland. For smaller regional or remote court locations, there may be a file lawyer that covers multiple smaller court locations.
And Nicholas, we're just getting a question coming through. Is there a website where people can go to see if their local court would typically have one file lawyer or multiple, or is it a case-by-case basis as well as based on the location?
Okay, so in terms of the best way to ascertain, I guess, who is involved in a particular matter is to contact our general inquiries line, or otherwise contact the applicant lawyer, and they can then advise who the file lawyer is responsible for that matter. If someone is regularly practicing in a particular location, it is consistently, in the smaller centres, it will be consistently the same person. So for example, Mackay or Rockhampton, like I've said. But in terms of court locations where matters are heard, I would note that there are certain particularly very small courts around the state where child protection matters are not routinely heard. So it's not every magistrates court that will hear a child protection matter. But in terms of determining who the file lawyer is with carriage, I'd just direct that inquiry to the applicant lawyer or the inquiries line.
Thank you, Nicholas.
In terms of the child protection order application process, it does typically follow a set format, but it does sometimes look a little bit different depending on the matter, the complexities, and whether or not a participant is contesting the application before the court. So moving on, this is a general diagram of the overall process for a child protection order application before the Children's Court. So the applicant lawyer is typically involved more so at the earlier and later stages of the proceedings, and through the middle stages, that's predominantly the file lawyer who manages the matter at that point in time. In terms of the second point there around the mention space, there may be multiple mentions, and that can depend on a range of things, and in particular there can be adjournments for various reasons. Those can include for case plans to be developed for children, for parents to obtain legal advice, for reports or other assessments to be obtained, and that could be, for example, child safety commissioning, a psychiatric assessment or parenting capacity assessment, or for the separate representative to obtain a social assessment report. So I know the next part of this presentation will dive a little bit more deeply into the roles of the various participants in the process. So I won't speak too much more to that. But in terms of the interim proceedings, there can also be interim hearings listed in relation to matters such as temporary custody, contact orders, and other various sorts of orders or directions. The third point is the court order conference. That is a mandatory part of the litigation process where one or more parties or participants are opposing the order that's before the court. And the court order conference is an opportunity for everyone to come around the table and to discuss the issues in dispute, and with the intention of reaching a resolution as to the type of intervention that would be in the best interests of the child.
And Nicholas, sorry, there's just a question coming through. I know you've said that normally the respondent is parents, so they would be involved in the COC, but someone's asking if grandparents can step in and have their say at this point in time?
Yes, I'll maybe touch on that, but I'm mindful that's coming up in the next part. But yes, certainly there is scope for people aside from a child's mother or father to be involved at that stage, and especially so if they have been joined to the proceedings as a non-party participant under Section 113 of the Child Protection Act. So on a case-by-case basis, it may or may not be that extended family, for example, participate.
Thank you, Nicholas.
And the final point I'll touch on is that if there's no resolution at that court order conferencing stage, that the matter would then proceed to a final hearing. Shortly before the final hearing is a review mentioned to ensure that everything is ready for the hearing itself. And the hearing is the point at which the court will make a decision on the application, and that's the stage where witnesses might be called to give evidence. So I might just hand over now in terms of the next part of the presentation being participants in child protection proceedings.
Thank you. Georgia, would you like to comment on the parenting slides here?
I would. So thank you for that in-depth explanation about DCPL's role and the court proceedings. I work at Legal Aid Queensland, and so I represent quite a few of the other participants who might be involved in a child protection proceeding. First and foremost is the parents. We have quite an expanded definition of parent in child protection proceedings. It could be a child's mother or father, but the definition also does recognise someone who, under the administration of another act, has parental responsibility or guardianship for a child. So for those of you working in the Federal Circuit Family Court space, you'll be familiar with parental responsibility orders. It covers those sorts of relationships as well. In terms of our Aboriginal and Torres Strait Islander families, it also recognises that there can be a wide understanding of who is considered to be a parent in that context to a child, and it allows those people to participate as parents as well in the proceedings in certain circumstances. We also,
sorry, Georgia, was that too soon?
That's fine.
Okay.
We also have separate representatives. So a separate representative is a lawyer who's appointed by the court that doesn't act for the parents and they don't act for the DCPL. Their role is completely separate and they are really there to do an independent investigation on a best interest basis. So they look into what they think is in the best interest of the child after doing their research and getting expert reports if they're appropriate, and then presenting their own case to the court. So that might be different than what everyone else is seeking, but they are very important in those proceedings, particularly where there's quite severe risk or where they're very complex cases. The separate representative's role is extremely important in making sure that all of the necessary evidence is before the court that might not necessarily be put forward by other participants in the proceeding. More slides. The court, in consideration of whether or not it's appropriate to appoint a separate representative, must consider the circumstances of the child, the circumstances of the family, factual or evidentiary complexity of the proceedings. So that goes to whether or not it's something that might require a little bit more investigation and they think they need someone who can do those investigations. For example, if we needed psychiatric reports, sometimes that's something that the separate representative might look into. And they really undertake a different role than what the parents might or what the DCPL might. So there are a number of things that the separate representative is required to do. They must, to the extent that it is appropriate, taking into account the child's age and ability, meet with the child, explain their role to the child, and assist the child to take part in proceedings. Age and ability is really important in that regard because the way that they might engage with a very little child is completely different to the way that they might engage with teenagers who tend to have a lot of views that they like put forward and things that they would want the court to consider. And that's discretionary for the separate representative in how they think it's appropriate to present that to the court in a child-focused way that also respects the child's views and wishes, because that's something that the court needs to take into account.
Thank you. And we've just got a question here, if you don't mind me jumping in. Other than going through an administrative review process in the court, are there mechanisms in place for internal review of the application of policies and procedures available to parents or caregivers relating to a pathway matter, how the pathway matter is managed from reporting to orders being put in place?
I think that's quite a broad question, and it would really depend on what mechanisms you're relating to or you're speaking about in that question, because child safety, when they make decisions, issue things called reviewable decision letters. And I believe the process that you're talking about in the court application would be that application to QCAT, where you can have a decision reviewed if it is set out in a reviewable decision letter.
Yep, that might be a question that could be emailed to us, do you think, Georgia?
I think so.
Yeah, more.
If you wouldn't mind going into a little bit more detail and specifying some examples maybe, then we might be able to get back to you in how you would respond to each different case.
Yeah, and the email address for that, so if anyone does have a more complex question for the panel today, you're welcome to email your question through. The email is webinars, webinars, @legalaid.qld.gov.au. All right, we'll move back to the slides now. going to the next
Yes,
slide,
please.
Georgia?
Thank you.
Okay.
So I think I've covered most of these aspects of the separate representative role in my earlier discussions, but I don't think I said they review the file. They do. They are required to read everything. They read everything the DCPL files. They read everything that parents or Section 113 apps file, and they're across all of that. And then they also sometimes issue subpoenas and will review all of that information. So they are required to be across all of the evidence as well. Now, different to a separate representative, but sometimes confused about the role between the two, is the direct representative. A direct representative is a lawyer that will actually engage with the child on a client solicitor basis. And that's really important because that gives rise to obligations of confidentiality as you ordinarily have in a client solicitor relationship. Whereas in a separate representative child relationship, they don't have that obligation. So that's one of the key distinctions. And we also take instructions from a child rather than running a case on a best interests basis. So we will, of course, advise the child about what we think might be in their best interests or might be in conflict with their best interests, but we are required to take instructions. However, that is all on the basis that they are GILIC competent. GILIC is the test that we apply to see whether or not a child is actually able to understand and instruct a solicitor, and that's really important. And it's also an interesting question in and of itself, because one of the things that I seem to come across frequently is people believing that a child turns 12 and then they are able to instruct a lawyer. And I don't know what the magic is around the number 12, but that seems to be something that people think. It's much more complex than that, because capacity can be fluctuating. It can be impacted by circumstance. It can be impacted by whether or not the child is appropriately supported in that interaction when the capacity assessment is being made, and whether or not age-appropriate language is being used. So that's something that it's really down to the lawyer to exercise some discretion on when they're assessing capacity, but it's also an ongoing assessment. So a child may have capacity for certain decisions, but not other decisions, or their capacity might be impacted throughout the proceedings. And that's a really important aspect of the direct representative role, is understanding whether or not your client has the capacity to instruct you, but also being respectful of the fact that they are a child. They need to be protected from some aspects of things that could be quite harmful emotionally to them, and that informs our practice as well.
Thank you, Georgia.
So I think I've actually just covered that. I should have been aware of this slide on its way, but they are the two ways that the separate representative and the direct representative are primarily different. Then we have another really important role, which is the role of the independent entity. So where it's been identified that children of a family are of Aboriginal or Torres Strait Islander heritage, they are entitled to have an independent person facilitate their participation in a family-led decision-making process. And that's really important because it ensures that the practices that are applied in relation to that family are culturally appropriate, and the child's culture is being respected and put at the foremost consideration in the decisions that are made for that child by everyone involved. So the IE is really important in terms of providing information around decisions such as how to keep the child safe, whether or not the child is actually a child in need of protection, the type of ongoing intervention that's going to be appropriate for that child and protect them, including protecting their access to culture, and also with whom the child lives.
Thanks, Georgia. And another question has come through about, because you mentioned ages of children earlier, in the court of law, is a child, and under child protection, is a child any child up to and including 17 years old?
Yes, that's my understanding.
Great, thank you.
So non-party participants, or as I refer to them, Section 113s, as that's the section of the Child Protection Act that talks about the ability of other people to be involved in proceedings. This is a really important section because it recognises the practicality that a child might have lots of important people in their life. Their parents are very important, but it also acknowledges that there might be things that the grandparents can support the child with, or a particularly involved auntie or uncle might support the child with. This section enables those people to become involved in proceedings, provided that they are able to offer information to the court that is essential for the decision making around the child, or are able to offer a perspective that might assist the court in determining what is the least intrusive order to ensure this child's safety. So it's a very important section. I've represented quite a few grandparents in relation to a Section 113 application, particularly where they were seeking that the child come and live with them rather than go into a formalised foster placement arrangement.
All right. Office of the Public Guardian, Mark, I might ask you to step in here and throw you in with a slide if you wouldn't mind, just talking a little bit about the work that the Office of the Public Guardian does.
Sure, thank you. So the Office of Public Guardian was formed, just like Nicholas was talking before, about the DCPL back in 2016 as a result of the County Commission of Inquiry. So we saw the merging of the Children's Commission with the Office of Adult Guardian to form the Office of Public Guardian. So within the Office of Public Guardian, we have 3 business units. So the Community Visiting Advocacy business unit, the guardianship team, and also the Legal Services Investigation team. So principally the Community Visiting Advocacy team, where I'm from predominantly, we work with children and young people. So we have teams of community visitors across the state that go and visit children and young people in care. So they work as an advocate for the child and young person, and so their role is to check in with them, ask them how they're going, what service delivery is looking like, if they've got any issues or concerns or complaints perhaps. So we can raise those referable matters or issues with the Department of Child Safety, and there's consistent with the Memorandum of Understanding in relation to complaint management and information sharing between the 2 agencies. So the community visitor will, if there are concerns regarding service delivery, gaps in that occurring, then raise those directly with the child safety officer and or the senior team leader with a view of seeking a satisfactory resolution. So sometimes it could be a legal issue involved. It could be child protection proceedings, in which case the community visitor will then do a referral to inside Office of Public Guardian across to the Legal Services Investigation team. And at that particular point, the child advocate legal officer within the Legal Service Investigation team will take carriage of that matter and then engage in advocating the legal rights of the young person with those particular proceedings. So it could be a court order conference, it could be child protection order proceedings that the child wants to be heard about. So that's predominantly what we do. There's also a framework in terms of raising complaints, so that gets raised and elevated to a child safety service manager, which Essie and George talked about before. So that's it as an introduction in terms of what we do. Just touching on the points raised before by George about the SET rep, the direct rep, and the child advocate legal officer. So the child advocate legal officer is an advocate on legal matters. They are lawyers that are employed by the Office of Public Guardian, and they will liaise with the lawyers involved, and so in some instances might then participate in the direct submission or application to Legal Aid Queensland for a direct rep to be appointed to the child or young person. Also, they might get involved with conversations in terms of the SET reps participation in the proceedings, and so they might have those conversations. They don't appear as such, they don't appear as their legal officer in court. They're just sort of behind the scenes providing that advocacy, expert legal advice to them. So if we can move on to the next slide.
Also just jumping in with another question, is there anything else you'd be able to explain about the role of the legal guardians for adults?
Yeah, sure. So so in relation to particularly as it relevant to children and young people, we have a pre-advocacy team within the guardianship team. And so their role is to link with child safety and to develop an application to QCAT for the consideration of the Office of Public Guardian being appointed as guardian for the young person. This is obviously really, really important for transitional to adult planning. So at 17.5 years of age, we do advocate and work towards the a process with QCAT to have a public guardian appointed, or a guardian appointed with the Office of Public Guardian. It is as a last resort. Obviously, under the Guardianship Administration Act, there's responsibilities to ensure that, you know, where there's someone that is able to and meets the criteria and is suitable and should be the guardian for that particular young person, you know, post 18. But you might find obviously children in children's residentials where they're transitioning from out of long-term out-of-home care, out of a children's residential into the adult world. They may not have a suitable guardian in that instance. Although the flip side of that is you might have a child or young person that's been with on a long-term guardianship order or permanent care order with a foster carer, for instance, or someone significant like that. And so it's going to be easier to nominate a guardian in that instance. So it's a last resort. It's the least footprint approach, I guess, towards the state being appointed a guardian for a young person. But we do have that option at facility there.
Wonderful, thank you for that, Mark. I'll just jump in with another slide, throw you on the spot here, sure. If that's okay.
That's okay. So this is the child advocate legal officer whose their functions within the legal services and investigation team. So like I mentioned before, they provide information and advice on legal matters to children and young people in care. In out-of-home care, they advocate for the child to ensure their views and wishes are expressed in court proceedings. And so they advocate for, you know, obviously they have that legal background and can facilitate and guide and shape conversations with the children and young people, but they are advocates for the children and young people. And so they give that legal advice and that legal interchange or interface between the legal system and themselves. So they can facilitate the going along and doing expert sort of intervention at family group meetings and court order conferences, sitting there as an advocate for the child or young person who wants their views and wishes heard. And so everyone within the child protection system understands that they're just sort of a direct advocate for the children and young people.
Wonderful, thank you for that, Mark. I'll just ask you to talk a little bit more about OPG and how you're assisting vulnerable adults as well. I know I did ask you and you did touch on it earlier. So we can save this for the handout unless there's more you wanted to comment on that here.
Yeah, sure. The adult guardian. So depending on the types of matters that the public guardian is appointed to, the guardians within the guardianship team will be appointed as guardians or case managers of the adult person. And so they, depending on the matters that have been appointed, whether it's health or general matters, it's not so much finance that's over in with the public trustee, but they can represent and they case manage as guardian for the adult, vulnerable adult that's in care. And we also have a visiting function. So our community visiting advocacy team do have community visitors that go and visit vulnerable adults in adult settings. So they follow up and likewise can raise issues or complaints with service providers and or escalate matters to the NDIS Quality and Safeguards Commission. So we have pathways there and a liaison and certain policies and protocols there.
All right, thank you, Mark, and thank you everybody for your valuable input being today's panel. I've definitely learned a lot myself, and I'm sure our audience have learnt a lot as well. And our audience have been asking questions along the way, which is fantastic. We now have a little bit of an opportunity. If you do have any other burning questions, you can ask our panel today. Otherwise, if you had any questions for each other, you're welcome to, or if you've got any top tips that you wanted to share with the audience, just a quick takeaway from your slides today, then that could be really beneficial for our audience as well.
I'm just going to jump in and maybe comment on Georgia's definition on parent. Just conscious of that question that could come earlier about whether a grandparent could be involved. I just wanted to just make sure it was clear that the definition does change application. So often if the grandparent was involved in the investigation assessment period, because the definition of a parent is much wider, it means the department can interact with a grandparent at that stage. But as soon as we have to file an application, then the definition narrows, which then means unless the grandparent takes on a Section 113 application to be involved with the proceedings, we sort of get shut out of it. So I just say that respectfully, that that's an avenue you can take in order to get back involved, because you might wonder, how come I've dropped off? And that could be the reason.
Yeah. Thank you for that insight, Essie. That was really helpful.
Just want to be helpful.
Yeah, no, that was very helpful. Definitely very valuable. Thank you. Are there any other comments or tips or questions?
Yeah, I just had one. It's not so much a question, but I just thought for completeness I'd maybe raise it. I certainly focused a lot on the making of a child protection order application, but I thought certainly there's other types of applications that go before the Children's Court, and that can be to vary or revoke an order that's already on foot, and that's also quite commonplace. But the majority of applications are to make a child protection order.
Thank you for that, Nicholas. Georgia, are there any top tips that you could leave our audience with today?
I think my biggest top tip, I know we have a large legal audience, but this one's probably more directed towards our service providers who are working with clients in a non-legal capacity, is at Legal Aid we have a bit of a no wrong door policy, which is if you're not sure if there's something that we can do to assist your client, even if they're in that really early stage of engagement with child safety, or they're just curious, or even you as a stakeholder are just curious, we really encourage people to get in contact with our in-house child protection team. We love hearing from stakeholders and building those relationships and answering questions, because you never know if there's something that there might be that we can do to assist a client. We have duty lawyer services, we've got outreach services to our regional courts. We have the early legal service, which works with families in that pre-court stage, which is completely different to a grant of aid, which normally covers where there's actual litigation happening. So there's a lot of value to be made in just making that referral for your client, because there might be something that we can help them with, or at the very least, we could try to point them in the right direction. So that would probably be my top tip for anyone working with people in the child protection space.
Absolutely, yeah. When in doubt, get in touch with any of the commissions here today. Everyone's got a hotline that you can call. And we've got another question that's come through. Someone's really interested in child protection and mental health. And are there any extra services that are offered in any of the commissions today to help people who are going through mental health challenges at the child protection system?
We have lawyers at Legal Aid who, I guess it depends whether or not you're talking about mental health in a mental health court context, or they're experiencing mental health and that's a child protection concern. But we at Legal Aid, our child protection lawyers, do work a lot with people who are experiencing mental health as a complex issue in their life at the moment, and we are quite experienced in working with that. But we also have teams at Legal Aid that deal with criminal matters in the mental health court context. So again, if you want some more specific responses to that, I'd be more than happy to answer a question by email if there's a particular case study that you have in mind that you'd like some light on.
Thank you, Georgia. Yeah, and the email address again is webinars@legalaid.qld.gov.au. You're welcome to use that email address to ask Georgia, Essie, Nick, or Mark anything, and I'm happy to pass that on to the relevant person. That's all the questions that we've had time for today. So I just want to say a really big thank you to Mark, Nick, Georgia, and Essie for coming together to provide such a valuable panel and such valuable information for our audience today. We've had over 60 people join us live, which is fantastic. And I know that many of you send it on to your colleagues and use it as staff in-house training videos as well, which is really wonderful. So thank you so much for your content, and thank you to the audience for asking all of your burning questions as we went along today. And I will just say we do have another webinar coming up on child protection, and the information for this is, my slides aren't moving through here, but the information is in the handout. So if you wanted to download the handout or jump on to the webinars page on the Legal Aid Queensland website, then you'll be able to see our child protection program for this month. All right, and thank you to our live captioners and our Auslan interpreters as well. And we'll see you all at the next webinar.